This is Tom Higgins. The topic I'd like to talk about now is what if the worst happens, if you're in fact convicted of a criminal case. There are two methods to get the court to look at that. One is called an appeal. The other is called a post-conviction relief. In Arizona, it's Rule 32 of the criminal procedures. A similar situation in federal court, it's called habeas corpus. But a post-conviction relief is only available on 7 enumerated grounds in the rule. In the most commonly used is ineffective assistance of counsel. Clearly, the attorney that represented you at trial or in a plea can't do that for you because they would have to raise it against themselves. But of the 7 grounds, that's the most common. The problem with a Rule 32 is that if you do a change of plea, not a trial, a change of plea, then you're looking at 90 days to bring up one of these 7 items, and they include such things as ineffective assistance of counsel, newly discovered evidence, a change in the law, and things like that. If it's from a change of plea, it is extremely difficult to get relief, well under 5%. And the reason is you don't do an appeal, you file a Rule 32 with the trial court, and you go back to them. You cannot, in fact, do an appeal from a conviction because of a change of plea. You go back to the trial court and ask them to correct it for the various reasons that you have. So there's not much of a record. It's not like a trial where you have prosecutors acting up, you have judges making mistakes, and you have a complete record. So the chances of a Rule 32 after a change of plea are not very good. And people get overly enthusiastic because they got more time than they thought they should have. But a Rule 32 is, like I said, less than 5% chance. You can also raise a Rule 32 even if you had a trial and an appeal. A Rule 32 goes back to the trial court again on one of those grounds, but you have a better record for it. The appeal is done. You have 20 days after a conviction in state court to file a notice of appeal with the Court of Appeals. The Rule 32, you have 90 days to file the notice, and then you have 60 days after that to file the paperwork. And those are a hard and fast rule from a change of plea. Appeals can take any amount of time. I've had them as short as 3 months and as long as a year. It depends on the issues involved, how much time you need to flesh them out in the what they call the opening and reply brief. And those things are very time-consuming. A lot of work goes into research. The thing about criminal law is it changes so rapidly. A lot of times you end up having a case dismissed because after the person was arrested, they changed the law, and it's no longer a crime. That happens occasionally. I'd like to close by saying it's only a phone call away to find out about your situation. It will probably result in a free office conference. A lot of times with Rule 32s, you don't have all the records, the filings in court, the court documents or minute entries, the rulings, the sentencing and stuff, and you certainly don't have any transcripts. So those things take longer, but the initial conference is free. Give us a call, visit us online, and we'll help you with the problem. Thank you very much.